Will hear me. Right, I will try to stick to the principle of maximizing the breaks and the question time, so I'll try to be short. And there was light. Okay, I'm going to start off by saying something about the United Kingdom, not because I am particularly Anglophile. In fact, I tend to object quite strongly to the hegemony of the English language around the world. But the reality in this particular subject is that it's in the United Kingdom that there has been the longest and most public experience with religious tribunals. So it's in the United Kingdom that there has been the most discussion, the most writing, the most analysis of principles which are relevant, and therefore we can perhaps learn more interesting concepts and experience from the United Kingdom than from any other country. And the other big European states that I've mentioned there, I will refer to them shortly, more by way of contrast than in a material context. First, a little bit of school teaching, because I have found, this is another thing that I object to violently, but I can jump up and down as much as I want, it doesn't help. Most people in the world seem to think that the United Kingdom is actually Great Britain, and it's not. It's quite important to point out the difference between them. Many people also think that England is Great Britain, or that England is United Kingdom, which also is not true. The United Kingdom is the same thing as Israel, or the same thing as Switzerland. It's a state recognized by law. England is not. Great Britain is not. Great Britain is a geographical concept. Great Britain is an island. It's a single island. The United Kingdom consists of 4 legal orders. There are 4, it's not a federal state, but nevertheless there are 4 countries within the United Kingdom, each one with its own legal system. I've listed the 4 of them there. Great Britain has 3 of those countries more or less present on its territory, but because Great Britain is one island, so for example the whole of Scotland is not on Great Britain. Islands like the Isle of Skye or the Orkney Islands, which are part of Scotland, are not part of Great Britain, because Great Britain is a single island. So just firstly to clarify what we're talking about, the United Kingdom. Now, which purely religious tribunals are currently sitting in the United Kingdom? Well, I undertook a fair amount of research, and I tried to find out whether some of the smaller, less visible religious groups may have tribunals. I know the Sikhs don't. The Sikhs expressly say, we think religious laws are a bad thing. We don't want religious laws. They just prevent us from coming closer to our brothers and sisters, and so on and so on. I have not found any evidence of religious tribunals for groups like the Parsis, or like the Hindus or the Buddhists in the United Kingdom. The 3 religious groups which seem to have tribunals functioning are the Roman Catholics, the Jewish and the Muslim communities. I've listed them there from order of most numerous through to least numerous in number of religious tribunals, but I'm going to start a little bit differently. I'm going to start with the Catholics first, because the Catholics are perhaps the oldest community in the United Kingdom with religious tribunals. The Catholic diocesan tribunals are mainly concerned with purely religious matters. They're really concerned with what goes on in the church, with who should be appointed to what post and who should be rewarded with what title and so on. But they do also settle disputes between people, between parties, between believers, and they in fact settle only one dispute between believers, and that is the question of the existence or not of a marriage. So if you are Catholic and you want to, in reality, if you want to have a decision saying that your marriage doesn't exist, as Justice Manohar told us before in the funny story that she told us, if you want to have a decision saying that in the eyes of the Church your marriage never existed, it's void, it's null from the beginning, then you can go to the Catholic diocesan tribunals, and that's the only legal, non-internal legal issue that they deal with. They refuse to deal with other issues. Very different is the situation of the Jewish Bet Din in London, which exists, if I understood correctly, for about 300 years now. I must say that I'm a bit nervous to say anything about Jewish courts and Jewish communities in front of this audience. I feel like I've gone to see the Eskimos to give a lecture about snow. So if you hear me say something stupid or simply wrong, then shout and correct me. The Jewish Bet Din publicly says that it is prepared to hear and settle all kinds of disputes. It is available for people of the Jewish faith to come to submit whatever disputes they have. In fact, it even says on the web page of the Bet Din, if you are of the Jewish faith, you have a religious obligation to submit your disputes with other Jewish people to the Jewish court. You should not go to the secular court. So if you have a boundary dispute between your two houses, or if you have a contract dispute, or whatever it is, a succession matter, you should go to the Bet Din. The Sharia councils in the United Kingdom have basically the same fundamental point of view, but in reality they are more conservative in a certain sense, because they are, we'll come to this afterwards, are very open to public criticism. They tend to restrict themselves to matters. For example, they will deal with marriage, questions of marriage and divorce only after a civil divorce has been decided. If the couple have married civilly, then they require a civil divorce before the Sharia court will deal with the matter. It's hard to say how many Sharia tribunals there are in the United Kingdom, because they don't necessarily all have an internet site and publish materials and so on. There are a couple which do. There are a couple which have very formal procedures, all kinds of documents that you can download and where you can follow the procedure exactly as you would before the High Court of Justice. There are many others which simply consist of a mufti or a imam who decides matters after talking to the two parties in his office. So there are more and less formal tribunals. The Muslim community decided about 5 years ago that they should create something much more stable and formal and public, so they established this Muslim Arbitration Tribunal. The Muslim Arbitration Tribunal is actually something similar to the Permanent Court of Arbitration in The Hague. I don't know if anybody has heard of it. The Permanent Court of Arbitration is actually not a court at all. It's a structure which allows states to agree upon arbitrations according to set rules. Well, the Muslim Arbitration Tribunal is the same thing. They invite people who want to settle their disputes according to Islamic law to fill out forms and to agree to establish an ad hoc arbitral tribunal for each particular case. And the Bet Din, the Jewish Bet Din, has the same mechanism. They explicitly say, if you want this decision to be recognized before state instances, then you should frame it as an arbitration proceeding, and the arbitrators will be the Jewish law experts. So that's the approach that's taken by these tribunals. A short word about how important these tribunals may be in the United Kingdom. I've given some information there about the population. The difference between the population of the UK and Great Britain being that in Northern Ireland there are almost 2 million people who live, and therefore they do not live in Great Britain. They live in the United Kingdom but not in Great Britain. It's important to make a distinction because the statistics which have been gathered until now about the religious adherence of people, British people, these statistics have been collected only for Great Britain. They haven't been collected in Northern Ireland. So these statistics, the three which I have there at the bottom of the screen, they're statistics for Great Britain, and they show there roughly the percentages and the number of people who are professing members of these three faiths. If you put the three number of millions of people together, you arrive at something very similar to the whole population of Switzerland. So this is not a negligible number of people. This is a quite important number of people. It's really a large population of people who, by their own statements, claim to be people who could very well be submitted to the religious tribunals. And finally, by way of introduction, a little bit background introduction, two things that happened recently which sort of set the tone, and which, when I speak to people, well, I'll come back to this afterwards as well, you see that this happens all over the place. In the year 2008, a very important religious person, the head of the Anglican Church basically, the head of the established Church of the United Kingdom, gave a lecture to lawyers. So it was a legal lecture. It was a technical lecture where the Archbishop reflected upon the place of religious communities and religious norms in modern society, in the modern British society. And in the course of this lecture, he mentioned the word Sharia, and he suggested that perhaps people of the Islamic faith may want to settle their disputes according to this. And this was enough for the media to, the next day, produce title pages with letters sort of 20 centimetres high, explaining that very soon, if you go and drink a beer in the pub, you will be sentenced to being stoned to death by the Islamic Tribunal. This kind of reaction. Then a few years later, introduced into the Parliament a lady, a politician who received the title of Lady or Baroness or something like that. She introduced this draft legislation into Parliament, and what it actually said, this draft bill, was that you would commit a criminal offence if you called yourself a judge and you were not a judge of a state court. So if you claim to be a judge of a religious tribunal, you would commit a criminal offence. If you were involved in something which was not a state court and you called it a court, you commit a criminal offence. And if you pretended that you could settle cases, that you could decide cases as a court, then you would also commit a criminal offence. This legislation did not advance very far, happily, because people who understand a little bit about alternative dispute resolution, who know something about the way that the law functions in reality in a sociological perspective, explained that this kind of norms, these kind of criminal norms, would be completely counterproductive and had no sense in a modern liberal democracy, and so the thing didn't advance. But there's obviously a very clear parallel to the case of the Oklahoma legislation, which Professor Englard talked to us about at the beginning of his lecture this morning. Now, this is now the little bit which is technical. Okay? Two slides which are technical, so bear with me. There are two formal relationships between religious tribunals and state law in the United Kingdom. One I've already mentioned, which is arbitration. Now, how does arbitration work? Well, under the Arbitration Act, anybody who's got full mental capacity can agree with somebody else who's got full mental capacity that they are going to submit their dispute to an arbitral tribunal. So you sign a contract saying, we want to have this settled by the arbitration, and then you go through the arbitral process. The arbitrator or the arbitral tribunal gives its sentence, hands down its judgment, and then either of the parties or both of them can basically insist that the state courts should enforce that in the same way as a state court judgment. So if you sign a contract saying, I contractually agree to arbitration, then afterwards it can be enforced on you in the same way as if you were before the court. That's the way that arbitration works. The only way that you can wiggle out of it afterwards is to say, well, the arbitrator was drunk during the hearings, or the arbitrator discriminated against me because he hates me, or whatever. But even arguments saying the arbitrator is completely stupid, doesn't know what he's talking about, didn't understand the law, and handed down a judgment which makes no sense, this is irrelevant. You agree to arbitrate, you get stuck with it. There are two acts of Parliament, one about children, one about marriages, which say that family law matters cannot be brought within that structure, in the sense that the state courts always have jurisdiction to decide by themselves and anew about any matter of family law. So you can have a family law arbitration, but the result of the arbitration is not binding. The judge can decide to go into the whole matter again. So there's not much point in arbitrating about family law. Second, mediation. Mediation is the modern thing. It's the sort of future of dispute resolution. These days in the United Kingdom, the state courts they are obliged to encourage people who want to come before the court. The judge tells them, before you come to me, why don't you try and settle your dispute by mediation? So that's required. Even if you've got a family dispute, if you're disputing with your spouse, then you're not even allowed to begin the proceedings in court until you can show that you've been to mediation, you've tried mediation. Mediation is compulsory, more or less. Where can mediation lead to? What's the sense of mediation? The idea is getting to yes, as the US Americans say. The idea is that the two parties, after mediation, will be happy with a certain solution. They will say, we agree on this solution to our dispute. Hello, Mr. Judge. Here is a draft of a judgment. We have agreed what should be the result of our dispute. Here's what we think. Could you please sign this? And the judges who have got more than enough cases to settle, who don't need more work, are normally quite happy to sign these consent judgments. If there are children involved, if there are the possibility that one of the parties is disadvantaged, that one of the parties was not able to freely participate in the mediation process, then the judge will review that. The judge will not automatically sign it. But the idea of mediation is that you get, in the end, to a consent judgment of the court, which is then binding on both the parties. Now, the important thing about mediation is that in the UK at least, and I think in most countries, there are no official mediators. You don't need to have a state accreditation as a mediator. There are some, what they call kite mark systems, where you can join a mediators association, and the mediators association says, yes, you are trained and you are intelligent and you know how to deal with difficult cases and so on. But that's not compulsory. Anybody can be a mediator. So for the purpose of this mediation structure, you can appoint any religious instance that you want. You can appoint the rabbi. You can appoint a mufti. You can appoint the eldest of the congregation. You can decide, according to your religious beliefs, who you want to be, who will mediate the dispute, and who will effectively arrive at a decision. And that is mostly what the Bet Din and the Sharia councils do. They mostly act as mediators who manage to get the parties to a consensual decision at the end of the dispute. Now, I'd like to say 4 things about the substance of the relations between religious tribunals and the state courts in the United Kingdom, for a start. First, the experience shows that the degree to which the parties are ready to cooperate determines which forum they need to go to. Fora being important for one very practical reason, namely cost. Settling disputes is not cheap. If you need to hire lawyers, it's really not cheap. So the idea is to find a forum to settle your dispute with a minimum cost. If the 2 parties to dispute want to get to yes, if it's important for the 2 people who have a problem to settle that problem and to get on with life, then the cheapest, the easiest, the quickest, the best forum is mediation. They should do mediation. It's the best way to get on with their lives. If they're not ready to agree in any case, but they are ready to fight, this is what a lot of people love to do. A lot of people have a dispute, and what's important for the dispute is to fight in the dispute. Okay? So in that case, arbitration is a good solution, because arbitration allows you to yell at the other party. It allows you to come up with all kinds of arguments why the other party is stupid and what the other party has done bad things and so on. You can say all of that, and at the end you have the arbitration decision, which is enforceable, and everybody is happy with the way that the procedure has run. If one or both of the parties need to be pushed in order to cooperate in the proceedings, then okay, then you have to go to civil proceedings before a civil court. And if, as in the case of the husbands who refused to give a divorce and who preferred to spend 30 years in prison instead of cooperating in the procedure, there are some individuals who can finally only be dealt with in criminal proceedings. So people's approach to dispute resolution is very important in the issue of which tribunals are going to be engaged. Second perspective. In the United Kingdom, you have a very special situation. It's exactly the opposite of India. In the United Kingdom, there is no separation of the state from the established church. In the United Kingdom, the Church and the Church of England, the Church of Scotland, and the Church in Ireland are part of the state, and the Crown, the monarch, is head of the church as well as being head of the state. This means that the church courts are state courts. The courts of the Church of England are official legal courts. They're not in the same category as the Roman Catholic courts, for example. Historically, it also meant that the church courts were responsible for much the same thing as the Jewish law, the Jewish tribunals are responsible for in Israel. Family matters and succession matters were always within the jurisdiction of the ecclesiastical courts. When they decided to change that, when they decided to establish civil courts for marriage, for divorce, for children, for succession, they didn't change the substantive law. So you still have today modern state courts that sometimes have to refer to purely ecclesiastical principles that applied, that were created before 1857, and they continue to apply as part of the modern law because the church law and the state law are the same thing in those fields. Family law changed very slowly in the United Kingdom. That's probably why it changed so slowly in India as well, because another country was not changing any more quickly. It was only in the 1930s that the United Kingdom began to move its family law away from the traditional religious principles. So that's why the United Kingdom is a special country in this respect. Thirdly, it's important, I'm coming back now to the question of publicity and what people think about religious courts. Judges of civil courts have shown themselves to be quite open to cooperation with, to coexistence with religious tribunals. Why is that? Well, firstly, because judges are intelligent people, okay, normally. Secondly, judges know that their own courts, their civil courts, originally had religious backgrounds. They understand that. They know that there's no fundamental distinction between a religious tribunal and a court and a civil tribunal. Thirdly, many British judges until now, traditionally they are Anglicans, and so they have a certain presence in the Anglican Church, and so they understand also that religious tribunals have a function. They know what the function of religious tribunals is. They're often involved in it themselves. One of the judges of the family court in the United Kingdom who is particularly active in writing about religious tribunals and in welcoming the activities of Jewish and Muslim tribunals is a person who is at the same time a judge of the civil court and a judge of the Anglican court, of the diocesan court. So he knows both sides of the coin. And finally, even those judges who have no religious appurtenance and no religious experience, they find in everyday practice that you can't avoid religion. Because the judges in the United Kingdom, they have to decide all cases concerning children according to a completely clouds in the sky principle, which is the principle of the best interests of the child. So what is in the best interest of the child? You have to take every circumstance into account. So it's completely vast, and one of the circumstances that certainly has to be taken into account is the religion of the child. If the child has grown up in a religious family and a religious community, that has to be taken into account. So family and child law judges in the UK are constantly confronted with family issues, and they can't avoid them. Politicians, on the other hand, are not open to discussion about religious tribunals. They are not interested in any kind of coexistence. And why is this? This is because they know that their voters in the majority don't like this either. And in a democracy, politicians do what they think the voters for them to do. And of course, what do the voters do? The voters do what the media tells them they should do. So unfortunately, we have a rather difficult dichotomy at that level. And finally, an economic aspect on the matter. It has been shown that religious tribunals are efficient. The proceedings before religious tribunals tend to be relatively quick. It doesn't take a year or two to get through the procedure in a religious tribunal, and they're cheap. You don't need to pay boots, boots, boots and marching on solicitors, as well as the barristers, as well as the secretaries and so on to run the case. There are few people involved, it can be done cheaply. And that is something which is of fundamental importance at a time in history when states are required to save money, to reduce deficits, to reduce the public sector expenditure, and therefore are constantly cutting back the civil legal aid budget. We are living at the very end of a tiny short period in history when everybody had access to the courts. Until the Second World War, most people in the world did not have access to courts. You simply couldn't pay for them. And it seems the way that we're going into the future is that as of 2000 until the end of humanity, most people will not have access to the courts. You simply can't pay for them. So religious tribunals are a very sensible and accessible alternative. And in addition to this purely economic aspect, there is the finding that the religious tribunals are sometimes able to offer solutions where the civil tribunals simply have no solutions. And I've given there one example. They say that 45% of all the proceedings commenced in one of the Sharia councils are commenced by women who want a divorce but who are not married. It's similar to the funny story which Justice Manohar told us about the couple who came to see her, except that in this case they are married according to Islamic law. It's just that they never married according to the state law, and so for the state tribunals they're not married, so they can't divorce. So the woman can't ask for any matrimonial relief. So the state judge simply has to say, sorry, I can't help you, whereas the religious judge can. And there's also the aspect that has already been discussed this morning about couples who want to remarry. And if you have a religious belief and you want to remarry within your religious community, you need a religious divorce. I've written compare rather than Bet Din because the Bet Din doesn't give a divorce. It simply accompanies the process of the husband giving the get. But it's something that the phenomenon of the need for a religious divorce appears not only in the Catholic tribunals and the Muslim tribunals, but also in the Jewish tribunals. Now, I'm coming now to end off with my own sort of 6 cents worth. And to do that, I'm going to have a look at these 3 other big European states to see what is the situation of religious tribunals compared to the UK. First, France. There are, again, 3 communities which have religious tribunals, but you'll see that there are much fewer of them. The Muslim community in particular is very hesitant to announce the presence of tribunals. They don't even say that there are tribunals, they just say that there are mufti in the mosques. But the mufti is a person educated in religious law. The mufti is, by his calling, supposed to hand out legal opinions. He's supposed to resolve particular disputes by saying what is the law. So the mufti is finally a kind of court. And since about 2006, if I remember correctly, the Bet Din of the Consistoire de Paris is now operating in the same manner as the one in London. But all in all, these tribunals don't go around shouting about what they're doing. They keep a very, very low profile, probably because France is the great nation of secular approach. Since 1789, since their revolution, they are very, very proud of the secular state and very, very reluctant to touch religious matters. Germany. In Germany, you easily and quickly, if you do a little bit of research, you very quickly find that Germany has an extremely long and extensive history of Jewish autonomous tribunals. All kinds of Jewish communities around Germany had their own courts recognized by the state authorities for settling all kinds of disputes within the Jewish communities. The modern Jewish communities, the current communities that actually exist, say no single word of such a mechanism existing. No mention of it. There was one exception, which seemed to have existed because a certain man, a certain rabbi, had a particularly strong education in religious law and was recognized by Israeli religious authorities, and therefore he set up a rabbinical court in the very south of Germany, but there's no mention of it anymore because it seems he had an accident, and with him the court came to an end. So there were no formal Jewish religious tribunals in Germany. The justice minister of one of the German states suggested early this year that it would be a good idea if the Muslim communities set up their own tribunals. And there was immediately the same kind of reaction as there was in the UK 4 years earlier. Other justice ministers saying, in Germany, the state courts are the ones that look after the law. We don't need other courts. Or in Germany, the law is this one, and there's no room for any Islamic law. So, okay, these are people who basically don't understand the concept of alternative dispute resolution, but it's also a fundamental rejection of any kind of other law than the law which comes out of public institutions. In Spain, neither of the big communities make any reference to proceedings, but the situation is even more acute than that, because there were press reports a few years ago, and for those who don't understand Spanish, what the citation there from a newspaper says is that 7 people were put in prison because they were suspected of having formed an Islamic tribunal. So the implication from the newspaper, what the newspaper reporters understood, is that it's a criminal offence to form an Islamic tribunal. That they were in prison because they wanted to have a Sharia tribunal. In fact, not. In fact, the reason that they were put in prison is that a woman claimed that she had been sentenced to death by this tribunal and that they were going to execute her. And so they were charged with attempted murder and so on. But the understanding in Spain is that the mere idea of forming a religious tribunal is by itself something illegal and reprehensible and so on. So what's my conclusion? What approach should we take to religious tribunals? Is it a good idea to discuss religious tribunals in the general community? Is it a good idea to make proposals to set up religious tribunals? My response is no. It's a very, very bad idea. Don't discuss it. Just set up religious tribunals. If you want to have a religious tribunal, do it. Set one up. Have it going. Have a lot of proceedings settled by religious tribunals. Then you can get people in who can study it, who can show, who can see that there are many cases that are being settled perfectly well, perfectly amicably, very satisfactory by religious tribunals, and then they can show the public, look, it works, it exists, it's actually happening. The community is not collapsing around us because there are religious tribunals. It is possible, it can happen, it is happening. Don't be scared because this is existing.